My sister texted me a photograph of a deed. The photograph was taken at an angle on what looked like a kitchen table, and it showed a legal document with my mother's name on it as grantor and my sister Petra's name on it as grantee, and it showed a notary seal and my mother's signature in the signature line. The deed transferred my mother's house in Licking County to my sister as a gift. The deed was dated February 9th. My mother had been admitted to Riverside Hospice in Newark on January 16th. She died on February 22nd. The deed was dated 13 days before she died and 34 days after she entered hospice care. My sister sent the photograph with a single sentence that said, "Just so you know, this is already handled." I want to tell you what it was like to read the text message the first time. I was at work between sessions and my phone buzzed, and I picked it up and saw Petra's name and opened it and read, "Just so you know, this is already handled." And I felt the specific quality of a message that is designed to close a conversation before it has started. Just so you know, this is already handled. The construction of that sentence is the construction of a person who does not want a response. They are informing you. They are not asking. I opened the photograph, my mother's name on the grantor line, Petra's name on the grantee line, the date February 9th. I looked at the date February 9th for a long time. I took the screenshot. I called the hospice. I did not respond to Petra's text. I did not respond to it that day or in the following days, and she did not text again. And by the time we spoke through attorneys, the question of what I might have said if I had responded directly was no longer the relevant question. The relevant question was what the hospice record said about February 9th. The hospice record said everything that needed to be said. I read that sentence 3 times. Just so you know, this is already handled. I understood that I was being told that a decision had been made and a document had been created, and that both of these things were being presented as final in a way that was designed to communicate that my response to them did not matter. I took a screenshot of the photograph. I called the hospice. I had been at my mother's bedside for most of the last week of her life, and I had spent significant time at the hospice in the weeks before that, and I knew the nursing staff by name, and I knew the structure of how things worked there. I asked to speak to the nursing supervisor on record for the unit my mother had been on. She was named Diane, and she had been there on the nights I had come in late to sit with my mother, and she had the specific quality of competence and care that you recognize in people who have done difficult and important work for a long time without requiring recognition for it. I asked her whether my mother had received visitors on February 9th. She said she would have to check the log. She called me back in 20 minutes and said your mother's visitors on February 9th were your sister and an unidentified male visitor in the afternoon. I asked whether my mother had been ambulatory on February 9th. Diane said no. She said your mother had been on a continuous sedation protocol since January 28th to manage pain and discomfort, and that she had not been ambulatory and had not been in a condition to conduct business of any kind since at least the second week of February. I wrote this down in numbered points on my legal pad. Then I called an attorney named Marcus Webb, whose office was in Newark, and who had been recommended to me by a colleague as someone who had spent 15 years handling property and estate disputes in Licking County. Before I go on, if this story connects with something real in your life, please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Miriam. I am 36 years old, and this is the story of how a hospice nursing supervisor's visitor log, a continuous sedation protocol start date in my mother's medical records, and a property attorney named Marcus who had handled fraudulent deed cases in Licking County for 15 years gave me back my mother's house and confirmed what I knew about what had happened in that room on February 9th. Now let me take you back to the beginning, not the text message, before that. To the house on Granville Road in Newark, Ohio that my mother had owned for 26 years, and that was the specific kind of modest single-story house in a tree-lined neighborhood that becomes, over decades of a person living in it, not just a property, but a record of a life. My mother's name was Constance. She was 67 when she died. She had been a hospital administrator for 21 years and had retired at 63 and had spent her retirement in the deliberate and self-directed way of a person who has spent decades managing the demands of an institution and who has decided that the years remaining belong entirely to her own priorities. She kept a garden. She took a watercolor class every Tuesday for 4 years and had a stack of paintings that she kept in a closet and occasionally showed to people with the combination of pride and self-deprecation that people use for creative work they enjoy without claiming professional ambition for it. She read 3 or 4 books a month, mostly history and biography, and she had strong opinions about what she had read, and she was not shy about them. The house was hers completely. She had bought it with my father before the divorce and had kept it in the settlement and had paid off the mortgage 11 years before she died. She had updated the kitchen twice and had replaced the windows and had added a small addition to the back that served as her reading room, and that she had told me when she added it was the room she had wanted in a house her entire adult life and that she was glad she had finally built it. The house was on my mother's title alone. She had a will that left it to both her daughters equally, Petra and me. The will had been drawn up 8 years earlier by an attorney whose office was in Columbus and whose name I knew because my mother had told me she had a will and that it was taken care of. I had not seen the will. I trusted that she had handled it because she was the kind of person who handled things. Petra and my mother had a relationship that I will describe as complicated without going further into the specifics than are necessary for this story. They were not estranged. They spoke regularly and saw each other regularly, and there was between them the specific warmth and tension that exists in some mother-daughter relationships, where both people want the relationship to be closer than their natures allow it to be. Petra was 41 at the time of our mother's death and had been living in the Columbus area for most of her adult life. She had been more involved in the practical side of our mother's care in the last year than I had been, partly because she was geographically closer and partly because she had more flexibility in her schedule. I was working as a physical therapist at a clinic in Cleveland and had driven down for visits when I could and had spent as much time at the hospice as I could manage in the final weeks. The continuous sedation protocol that Diane had mentioned was something I had discussed with the hospice physician and the nursing staff during my visits. My mother had been in significant pain, and the protocol had been the decision of the care team in consultation with the family, which at that stage meant primarily Petra and me. I had been part of the conversation that approved it. The protocol began on January 28th, and it meant that from that date my mother was not in a condition to sign a legal document, to make financial decisions, or to conduct business of any kind. She was sedated to manage pain, and she was not conscious in the way that a person signing a deed would need to be conscious. I knew this from being there. The medical records would document it. The hospice records would document it. February 9th was 12 days after the protocol began. On February 9th, my mother was in a hospice bed on a continuous sedation protocol, and she was visited by my sister and an unidentified male visitor. I want to say something about what a continuous sedation protocol is and what it means in terms of a patient's capacity, because I think most people outside of healthcare have a general sense of what sedation means, but not the specific clinical meaning of a protocol of the kind that was in place for my mother. A continuous sedation protocol in a hospice context is a medication regimen designed to maintain a consistent level of reduced consciousness and absence of pain and distress in a patient who is in the terminal phase of a life-limiting illness. It is not occasional sedation. It is not a medication given once and then wearing off. It is a continuous titrated regimen that is actively maintained by the nursing staff and adjusted as needed to keep the patient comfortable. A patient on this protocol is not in a condition to conduct legal business. They are not in a condition to understand a property transfer document. They are not in a condition to exercise the free and voluntary judgment that a valid legal signature requires. The protocol is designed to remove consciousness and pain simultaneously, and it does so continuously. The hospice physician who signed the declaration in this case had been the attending physician for my mother's care for the full duration of her stay, and had direct knowledge of her condition on February 9th from the contemporaneous medical records and from the clinical assessments of the nursing team. That physician said clearly and professionally what my mother's condition was on that date. The court took that declaration seriously. It was the most important document in the case. The deed was notarized. The notary's name on the document and the photograph was a woman named Sandra Birch. I looked up Sandra Birch in the Ohio Secretary of State Notary Commission database because by this point in my life I had learned to check Notary Commission records as a first step, which I will explain shortly. Her commission was valid and the start date was 2 years prior, so the notarization was not the problem in the way it had been in other cases I had heard of. Sandra Birch was a real notary with a valid commission that existed on February 9th. The problem was not whether Sandra Birch was authorized to notarize. The problem was whether the person who purportedly signed in front of Sandra Birch was capable of signing anything. A notarization confirms that a person appeared and signed in the presence of the notary. If the person who appeared was not capable of understanding or consenting to what they were signing, the document is not valid regardless of the notarization. My mother was on a continuous sedation protocol. The notarization said she had appeared and signed. The hospice records would say something different about her condition on that date. Marcus Webb was exactly what a colleague's recommendation had suggested. He was 53 years old and had been practicing property and estate law in Newark for 15 years, and he had the specific combination of local knowledge and legal precision that comes from practicing in a county seat for long enough to know the recorder's office and the court system, and the particular kinds of disputes that come up in a county where farmland has been in families for 10 generations and where property transfer disputes have a specific texture and history. He listened to what I described and said, "I want to see 3 things immediately." He said the deed image, the hospice admission record, and any documentation of the sedation protocol. I sent them. He called me back in 90 minutes and said, "This is a strong case, and I want to move quickly because the gift deed has already been recorded with the county recorder, and it is a live document creating title uncertainty on the property right now." The Licking County recorder had the deed in its system. Marcus pulled the recording details and found that the deed had been submitted for recording on March 3rd, 9 days after my mother's death on February 22nd. Submitted 9 days after the death of the person who had purportedly signed it. The deed was dated February 9th, but it had not been presented to the county recorder until after my mother was dead. Marcus said this was consistent with a document that had been created with a future recording in mind, and that had been held until the grantor could not contradict it. He said the recording date itself was not conclusive on its own, since people sometimes delay recording legitimate deeds. He said it was consistent with the other evidence, and that the combination of the recording date and the medical records would form the core of the case. I want to say something about what Marcus called the recording date problem. He said it was not the strongest element of the case on its own, but that it added meaningfully to the picture that the medical records were painting. He said a deed dated February 9th that was not filed with the county recorder until March 3rd, 9 days after the grantor died, raises a specific question. Why was it not recorded during the grantor's lifetime? He said the most innocent explanation is administrative delay. Someone forgot to take it to the recorder's office until later, and that this happens with legitimate deeds. He said the less innocent explanation is that the document was being held until the person who could contradict it was no longer able to do so. He said when you are presenting this in court alongside medical records showing that the grantor lacked capacity on the date of the deed, the recording delay shifts from being an innocent possibility to being a consistent element of a specific pattern. It supports the picture. It does not create the picture. The medical records created the picture. The recording date was one more element that was consistent with what the medical records showed. I asked him if we would have won without the recording date. He said yes. He said the physician's declaration and the nursing supervisor's statement were sufficient. He said the recording date made it complete, but it was not load-bearing in the way the medical records were. I said I was glad we had it anyway. He said so am I. He said every consistent element helps. A judge who is reading a case that has one strong point is looking for weakness. A judge who is reading a case where every element points the same direction is reading a case that is hard to argue with. I said I understand. He said I know. He said now, let us prepare for Thursday. He filed a petition in Licking County Common Pleas Court to void the deed and cloud the title in the county recorder's records pending the court's determination. He submitted the deed. He submitted my mother's hospice admission record dated January 16th. He submitted the sedation protocol start date from the nursing notes January 28th. He submitted a sworn statement from Diane, the nursing supervisor, regarding my mother's condition on February 9th and her status under the continuous sedation protocol on that date. He submitted the hospice physician's declaration that my mother lacked capacity to execute legal documents from January 28th through the date of her death. He submitted the recording date of the deed March 3rd, 9 days after my mother's death. He submitted the will, which left the house equally to both daughters. He submitted a sworn statement from me. Petra's attorney filed a response arguing that the sedation protocol allowed for periods of lucidity and that my mother had been in a lucid interval on February 9th when she had signed the deed in the presence of the notary and 2 witnesses. The response said she had understood what she was signing and had wanted to ensure Petra received the house because Petra had been the primary caregiver. The response did not include any documentation of the lucid interval. It did not include a statement from Sandra Birch describing my mother's condition on February 9th. It did not include any medical documentation supporting the claim of lucidity on that date. It included a statement from Petra that her mother had wanted this. Marcus's reply was 8 pages. It said the claim of a lucid interval was a claim without medical documentation in a case where extensive medical documentation of the patient's condition on the specific date in question existed and said something different. It said the hospice physician's declaration was based on the contemporaneous medical records of the treating team and that a family member's assertion of her recollection did not constitute equivalent evidence. It said the burden was on the proponent of the deed to produce medical documentation of capacity on February 9th and that no such I want to say something about Sandra Birch. The referral to the Ohio Notary Commission Board was made because there are 2 possibilities regarding her role in this, and both of them required investigation. The first possibility is that she was present at the hospice on February 9th and witnessed something she represented as my mother's signature on a deed, and that in doing so, she either failed to assess the signatory's capacity as a notary is required to do, or she knowingly notarized a document signed by a person who was incapable of executing it. The second possibility is that she was not present at any point and that her name and seal were used on the document without her knowledge or consent, which would make her a victim rather than a participant. I do not know which of these is true. The Notary Commission Board and the prosecutor are presumably working to establish this. What I know is that Ohio law requires a notary who is asked to notarize a document to assess whether the person signing is who they say they are and whether they appear to understand what they are signing and to be signing it voluntarily. A notary who is brought to a hospice room to notarize a deed has specific responsibilities regarding the capacity of the patient in that room. Those responsibilities were not fulfilled in this case, regardless of the specific mechanics of how the seal appeared on the document. I leave the question of personal accountability to the processes that were designed to investigate it. Documentation had been produced. The hearing was on a Thursday morning in the Licking County Common Pleas Court in Newark. The judge was a common pleas judge named Thomas Elliott who had been on the bench for 17 years and who had the bearing of someone who has read the filings before arriving and who has formed a preliminary view that will be changed only by information not in the filings. He asked Petra's attorney one question directly. Do you have any documentation from the treating medical staff at Riverside Hospice indicating that Constance had capacity to execute a legal document on February 9th? The attorney said the documentation was in the form of family observation. Judge Elliott said he was asking about medical documentation. The attorney said there was none available at this time. Judge Elliott looked at the hospice physician's declaration and the nursing supervisor's statement for a moment. He ruled from the bench. The deed was void as executed by a person who lacked legal capacity on the date of signing. The recording was canceled. The property reverted to the estate for administration under the terms of the will. The matter was referred to the county prosecutor and to the Ohio Notary Commission Board regarding Sandra Birch. The estate was administered under the I want to describe the hearing in more detail than the legal summary gives. Marcus and I arrived at the Licking County Courthouse in Newark, and we sat at the petitioner's table, and Petra was at the other table with her attorney, and I looked at her briefly when I came in, and she looked at me, and we both looked away in the specific way of people who are in a room together that neither of them would have chosen to be in. Judge Elliott had the files open in front of him when he came in, and the way he moved through the papers told me he had read them carefully. He asked the question about the medical documentation, and the attorney's answer was the answer Marcus had told me to expect, which was that it did not exist in the form the judge was asking for. What Marcus had also told me was that a judge who has handled property and estate disputes for 17 years understands the difference between a family member's recollection of what they believed about a patient's condition and a treating physician's contemporaneous clinical assessment of that condition. Judge Elliott demonstrated this understanding in about 8 minutes. He looked at the hospice physician's declaration and at the nursing supervisor's statement for a moment, and then he looked at the attorney for a moment, and then he looked back at the papers, and he ruled. I had sat in a hospice room with my mother for many hours during the period those papers described, and I had known what was true, and the papers confirmed it, and the judge confirmed the papers, and the ruling followed from all of that in the specific way that facts that are documented tend to produce the outcomes that the facts support. I was glad for the documentation. I was glad for the careful people who had kept it. Marcus put his file away as we left the courthouse, and he said to me in the parking lot, "The records were exactly what we needed, and they said exactly what we needed them to say." I said, "I know." He said, "Not all cases are this clean." I said, "I know that too." He said, "You were fortunate that the right people kept the right records." I said, "Yes." I said, "They kept them for her, not for us." He said, "Yes." He said, "That is usually how it works." Will. The house was transferred to both Petra and me in equal shares. I have since bought out Petra's share. I own the house now. I have been to it 4 times since the transfer completed. The reading room my mother built at the back is exactly as she left it. Her books on the shelves in the order she kept them. Her watercolors in the closet stacked against the wall in the order she painted them. The particular quality of afternoon light through the south-facing windows that she had told me was one of the reasons she had wanted the room positioned the way it was. The room is full of her in the way that spaces fill with a person who has spent years in them attending to what matters to them. I sit in it when I visit. I read in it sometimes. I think about the books she had opinions about, and I have started reading some of them so that I know what her opinions were about. Petra and I have had one conversation I want to tell you about going through my mother's things after the estate was administered. She was organized in the way of people who have spent careers in institutional settings where organization is required and where the absence of it has consequences. Her personal files were in a filing cabinet in the small second bedroom that served as her home office, and they were organized into labeled folders that covered her finances and her property, and her medical records and her legal documents and her insurance, and several other categories that I found I could identify immediately from the labels she had written in her specific handwriting. In the legal documents folder, I found the will. I found the deed to the house from when she had bought it. I found the settlement documents from the divorce that had confirmed the house was hers. I found the survey. I found the survey that she had pulled out for the oak tree dispute and that she had apparently refiled in its correct folder after winning the argument it had resolved. I found a copy of the deed of trust from the original purchase. Every document relevant to the ownership of her property was in that folder in a reasonable order and with its date visible. She had kept the records of everything she owned, the way she had run her department for 21 years, which is to say completely and accurately, and in a way that any person looking for the relevant information could find it without being told where to look. I have continued this file. I have added my own documents to it. The quiet title ruling, the deed in my name, the buyout agreement with Petra. The file she started in 1997 now has my documents in it. I intend to keep them there in the same order and with the same attention she gave them. She was organized about things, and I am trying to be organized about this the way she was organized about everything that mattered to her. I have also added one document that was not in her filing system. I printed the hospice physician's declaration and the nursing supervisor's statement from the legal proceedings, and I filed them in the legal documents folder. They belong there. They are the documents that confirmed what was true about the house, and they should be in the same place as all the other documents that confirmed what is true about the house. My mother would have put them there, since the ruling. It was brief, and it was about the estate administration, and it was conducted entirely through that specific register of enforced civility that family members use when they are managing a situation rather than a relationship. I do not know what the outcome of the prosecutor's referral has been or will be. I do not know what will happen with Sandra Birch and the Notary Commission. I hold all of those things in the place where unresolved things that are no longer in my hands are held. I want to say something before I go. Not about Petra and not about the referral. About Diane. About the nursing supervisor who called me back in 20 minutes and told me that my mother had visitors on February 9th and that my mother had been on a continuous sedation protocol since January 28th. And that she had not been in a condition to conduct business of any kind. She told me this because I asked, and because she had the records, and because she understood that the records were relevant to what I was asking about. She did not know she was documenting a case. She was a nursing supervisor doing her job with the precision and care that her job requires. The visitor log and the nursing notes and the sedation protocol documentation had been created at the time of care for the purpose of care and for no other purpose. They existed because careful people had done their work carefully. When I needed them, they were there, and they said what they said, and what they said was enough. Thank you for staying until the end. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a man whose business partner had been collecting payments from 3 clients who had not been informed the partnership had dissolved and what the Secretary of State's business termination filing revealed about the timeline, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if someone sends you a photograph of a deed and a message that says this is already handled, the first question is the date on the deed. The second question is what the medical records say about the grantor's condition on that date. Both sets of records are either there or they are not. If they are there, they will say what they say. They said everything here. I want to tell you about Newark and about the specific quality of Licking County as a place because the land and the context matter in this story the way they always matter when a house has been in a family for decades and has absorbed the specific history of the person who lived in it. Newark is the county seat of Licking County in central Ohio, east of Columbus along the Licking River, in the part of Ohio where the landscape has the particular character of the transition between the flatter Central Plains and the beginning of the Appalachian foothills to the east. The neighborhoods near Granville Road, where my mother's house was, have the specific texture of places that were built in the post-war decades and that have been lived in continuously since, and that have the particular combination of maturity and ordinariness that comes from being thoroughly inhabited rather than newly developed. My mother had lived on Granville Road for 26 years. In 26 years, a person accumulates the specific knowledge of their place that comes only from duration. She knew which neighbors had been there before her and which had arrived after. She knew the history of the oak tree in the front yard, which had been the subject of a dispute with a previous neighbor about whether it was on the property line. A dispute my mother had resolved by pulling out the survey from the time she bought the house and establishing that the tree was entirely on her property. A story she told with the satisfaction of someone who had kept the relevant document. She knew the specific quality of the light in each room at each time of day and which seasons were best for which rooms. She had an opinion about every neighbor's landscaping decisions that she shared with me when I visited and that I found both specific and I want to say something about the will and what it means that my mother had one and that I had trusted she had one without needing to see it. My mother was the kind of person who handled things, and I knew this from 40 years of watching her handle things. She had told me she had a will, and I believed her because she was reliable about things she said she had done. When Marcus asked for the will early in the process, I was able to tell him that my mother had one and where it would be, which was in the legal documents folder in the filing cabinet in her home office, because that was where my mother kept legal documents, and I knew this from having watched her file things over the years. The will was there. The survey was there. Every document relevant to the house was there and in order and available to Marcus within 24 hours of his asking for it. I tell you this not to praise my mother's organization, though it is worth praising, but to say that the difference between having the documents available quickly and not having them available quickly is not a trivial difference in a legal proceeding. Marcus said to me at one point that the cases that take longest and cost most are the cases where the correct documents exist but cannot be found quickly because no one had a system. He said, "Your mother had a system." He said it helped. I said, "I know." I said, "I am going to maintain it." He said, "Good." He said that is the practical tribute to a person who was organized. You stay organized with the things they left you. Almost well considered. I want to say something about the hospice and what the specific environment of it was and what it was like to spend time there in the last weeks of my mother's life. Riverside Hospice in Newark is a freestanding facility, which is to say it is not a wing of a hospital but its own building. And it has the quality of spaces designed specifically for the end of life, which is to say it has been designed with attention to the particular needs of people who are dying and of the family members who are with them. The rooms are not clinical in the way hospital rooms are clinical. They have windows that are large enough to matter, and they have space for a person to sit for hours with someone they love without feeling that they are in the way of machinery. The nursing staff operated with the specific competence and sensitivity of people who have decided to do this particular work and who have done it long enough to understand what families need at this stage and to provide it without being asked. Diane had been the supervisor on the unit. My mother was on for 7 years. She had been present on several of my late-night visits and had on 2 occasions sat with me in the hallway for a few minutes and talked about my mother and about how she was doing and about what I should expect and about what would be the signs when things were changing. She did this not as a protocol, but as a person who was present and who understood that the family members sitting with dying people sometimes needed someone to tell them what they were looking at. I trusted her as a professional and also as a person, and when I called her after reading Petra's text, I called her because she was the person who knew the facts. I want to tell you about Marcus's explanation of what makes a deed void for lack of capacity. He said there are two legal tests that matter. The first is whether the grantor was capable of understanding the nature and effect of the transaction at the time of signing. The second is whether the grantor was in a position to make a free and voluntary decision. He said a person on a continuous sedation protocol in hospice care fails both tests. He said the sedation protocol is designed to produce and maintain a state in which the patient is not in pain and not fully conscious, which is by design the opposite of the state required for valid contract execution. He said the hospice physician's declaration was the most important single document in the case because it was contemporaneous and because it was from the treating physician who had direct knowledge of my mother's condition and who was in the specific professional position to assess capacity. He said family members can also testify to what they observed, but that the physician's declaration carries a different weight because it is based on medical assessment rather than family recollection. He said the opposing side's response would have needed a medical document of equivalent or greater weight from a qualified person with direct knowledge of my mother's condition on February 9th, and that without such a document, their position was very difficult to sustain. I want to tell you what it was like to read the deed photograph the first time. The message came in the morning and I was at work and I looked at the screen and saw "just so you know, this is already handled." And I opened the photograph and looked at it, and I felt the specific stillness that comes from looking at something that contains information you need time to understand fully. My mother's name on the grantor line, the date February 9th. I knew February 9th. I had been at the hospice 3 days before, on February 6th, and my mother had been barely responsive, and the nursing staff had told me that things were progressing in the direction they were progressing. She had been on the sedation protocol for 11 days at that point. I had held her hand and I had talked to her, and she had not responded in a way that indicated she was following what I was saying. I had driven back to Cleveland on February 7th, and I had been called back on February 20th, and I had been there when she died on February 22nd. February 9th. I looked at the date for a long time. I knew what February 9th had been. I knew what the hospice records would say about February 9th. I took the screenshot and I called the hospice and I wrote down what Diane told me and I called Marcus the next morning and I moved in the specific deliberate way that I have learned to move when something needs to be done correctly and efficiently and without the kind of reactive emotion that slows down the process of doing things correctly and efficiently. I was not cold about it. I was organized about it. Those are different things. I want to describe the 2 weeks between filing the petition and the hearing because I think the specific quality of that period is worth describing. Marcus had filed the petition and had secured a temporary order preventing any further transfer or encumbrance of the property pending the court's determination. The order gave me some stability to know that the property was not going anywhere while the proceedings were underway. But the petition was filed, and I also want to tell you something about why I was able to recognize the significance of the date on the deed when I first saw it. I was at the hospice on February 6th, 3 days before the deed was dated, and I had been there for 6 hours, and I had been in the room with my mother for most of those 6 hours, and I had seen what her condition was. She was not speaking. She was not opening her eyes in a way that indicated awareness. She was breathing slowly, and she was still, and her hands were warm, and I held them, and I talked to her, and I do not know whether she could hear me, and I am glad I talked to her anyway. The nursing staff had told me on that visit that we were entering the final stage, and that I should plan to be reachable at any time, and that things could move quickly from this point. I drove home on February 7th with that understanding. When I saw February 9th on the deed, I had a specific memory of what February 6th had looked like. And I knew that February 9th, 3 days later, was not a day on which my mother had signed a document she understood. I did not need the medical records to tell me this. I already knew it. The medical records told the court what I already knew. That is a specific kind of confirmation that has a particular quality when the records say the thing you already knew was true, and the court confirms it, and you are able to leave the building with the ruling in hand, knowing that the record has said out loud what was true. Hearing was set. And in the time between those two things, I was continuing to go to work and to drive back to Newark on weekends when I needed to be there to deal with estate matters, and to sit in the reading room of my mother's house and think about what had happened in it, and to make peace with the gap between what I knew and what I would be able to say in court, and whether those two things would be sufficient. Marcus told me during that period that the key factor in cases like this was the absence of a medical counter-narrative. He said Petra's attorney would need to produce a medical document or testimony that supported the claim of lucidity on February 9th, and that without it, the claim was a family assertion against a treating physician's contemporaneous declaration, and that courts in Ohio treated those two things very differently. He said he had handled 4 cases of similar structure in the previous 10 years, and that in each of them the absence of contemporaneous medical documentation supporting the claimed capacity had been decisive. He said he was not certain, but that he was confident. I said I understand the distinction between certain and confident. He said good. He said most of my clients do not. He said we will see on Thursday. I also want to say something about the recording date and what it means and why Marcus described it as consistent with the other evidence. When a deed is signed and notarized, the parties involved have the option to record it with the county recorder immediately or to hold it and record it later. There is no legal requirement to record a deed immediately upon signing. However, when you are looking at a deed that claims to have been signed by a living grantor and that was not submitted to the county recorder until after that grantor died, the delay in recording becomes a fact worth noting. My mother signed nothing after February 22nd because she died on February 22nd. The deed appeared at the county recorder's office on March 3rd, 9 days after her death. If the deed had been signed legitimately on February 9th by a capable grantor, the most natural course of events would have been to record it promptly. The delay until after death is not conclusive, but it adds to the picture that everything else was forming. There is something I want to tell you about the watercolors in the reading room closet. After the estate was administered and the house was transferred to me and Petra's share was bought out, I spent a day at the house going through the items that needed to be sorted and organized and decided upon. When I opened the closet in the reading room and found the stack of watercolor paintings, I sat down on the floor in front of them and I went through them one by one. There were 47 of them. They were not signed, but they were dated in pencil on the back in my mother's handwriting, the year and in some cases the month and year, and they spanned 4 years from when she started the class to sometime in the year before her illness became serious enough to prevent her from attending. They ranged from what you would expect of a person who had just started, careful and tight and slightly stiff, to the later ones which had the looseness and confidence of someone who had found their particular way of doing a thing and was enjoying it. The subjects were mostly landscapes and flowers, the garden and the views from the reading room windows, and several of the surrounding countryside that she had driven to and painted in the field. And the later ones had that specific quality of paintings made by someone who has stopped trying to paint the thing and started trying to paint what they feel about the thing. I looked at all 47. I have kept them all. I have hung 6 of them. I intend to hang more. I want to say one more thing about Diane and about what the record she maintained meant in this specific context. The visitor log at a hospice is not primarily a legal document. It is a tool for managing the care environment, knowing who is in the facility, tracking family contact for care planning purposes, making sure the nursing staff knows who has been with a patient and when. The sedation protocol documentation is a medical record, a tool for managing the patient's care, ensuring continuity across shifts, documenting the medication regimen and the clinical rationale for it. Neither of these records was created with a fraudulent deed in mind. They were created because careful healthcare workers were doing their job carefully, which in this context meant documenting what was happening with the patients in their care. The records said what they said about February 9th, not because someone had anticipated needing them as evidence, but because the people who kept them understood that accurate records are how you know what happened and how you make sure what happened is known. That is a specific thing about evidence that I find genuinely important and that I have thought about often since this resolved. Evidence is not primarily created for use in disputes. It is created as a byproduct of careful work. The carefulness of the work is what makes the evidence useful when it is needed. Diane was not thinking about courts when she logged the visitors and documented the sedation protocol. She was thinking about patients. The record she kept thought about courts for her. I have been thinking since this resolved about the specific structure of what happened and about what it tells you about how fraud of this kind fails. The fraud assumed several things that turned out to be wrong. It assumed that I would not look carefully at the date on the deed. It assumed that even if I noticed the date, I would not connect it to what I knew about my mother's condition on that date. It assumed that even if I made that connection, I would not have access to the medical records that documented it. It assumed that the documentation of my mother's incapacity would be either unavailable or insufficient to overcome the apparent formality of a signed and notarized document. Every one of those assumptions was wrong. I was a person who had been present at my mother's bedside and who knew what February 9th had been. I was a person who had Diane's direct line in my phone. I was a person who had a legal pad on my kitchen table and who wrote things down in numbered points when I needed to understand them. The fraud assumed a version of me that was less attentive and less organized than I actually am. It was wrong about me. I also want to say something about the physical therapist's relationship to documentation, because I think it is relevant in the way that Elena's nursing background was relevant to her story. I work in a field where every session is documented, every treatment plan is reviewed, every outcome is measured and recorded and signed. The documentation exists for clinical reasons, for insurance reasons, for continuity of care reasons, and for legal reasons, and all of those reasons are served by the same habit, which is the habit of recording what happened with accuracy and at the time it happened. I have been doing this work for 10 years, and the documentation habit is so thoroughly part of how I approach things that I do not think about it as a habit. It is just how I think about things. When Petra sent me the photograph and the message, I processed it the way I process a clinical situation, which is to say, I identified the specific factual question that needed to be answered, and I went directly to the source that would have the most accurate and contemporaneous documentation of the relevant facts. Diane's visitor log and the sedation protocol records were the equivalent of the treatment documentation in my own work. They said what happened when it happened. They were accurate. I knew they would be there because careful people had kept them. I want to tell you about the house. I want to tell you what the house felt like the first time I walked through it alone after the transfer completed. I had been there in the weeks after my mother's death for practical estate reasons, and those visits had had the specific quality of visits made under the pressure of tasks that need to be done. The first visit after the deed was fully in my name, and the estate was settled was different. I drove down from Cleveland on a Saturday morning in June, and I let myself in with the key I had had for 20 years, and I stood in the entryway for a moment with the specific quality of someone who has just arrived somewhere and who wants to let the place receive them before they start moving through it. The house smelled the way it had always smelled, the specific combination of the oak floors and the old books and a faint trace of the garden that came in when the south windows were open, and I stood in it for a minute with my eyes closed, and then I walked through every room. I saved the reading room for last. When I went into it, the afternoon light was coming through the south windows at exactly the angle she had described, and I sat in her reading chair and I looked at the bookshelves and the watercolors stacked in the closet door I had left open and the garden through the east window. She had built the room she had always wanted. I was sitting in it. I had been in many difficult rooms in the previous 8 months, and this was not a difficult room. This was the room she had built for herself, and that she had loved, and that was full of what she had cared about. I sat in it for an hour. I intend to sit in it for many more hours in the years ahead. That is what the records protected, not just the property value, this. The room and the light and the books and the chair and the hour. And about what it means to own something that someone you loved, built, and lived in, and that has absorbed the specific texture of who they were. I said earlier that the reading room was full of her, and I want to try to be more specific about what I mean. When my mother decided she wanted the reading room, she had a specific vision for it, and she had executed that vision with the specific care of someone who had been thinking about it for a long time, and who knew what they wanted. The windows are south-facing and large, and they are positioned so that the afternoon light comes in at an angle that makes the room warm without being too bright. The built-in bookshelves are floor-to-ceiling on 2 walls, and they are filled with her books in the order she kept them, not alphabetical and not by subject, but in the order that made sense to her, which I have been working to understand and which is becoming clearer the more time I spend in the room. There is a reading chair in the corner that she bought specifically for the room and that fits the corner exactly, and from which you can see the garden through the east window and the bookshelves through the other direction and the afternoon light coming in from the south. I sat in that chair for the first time on a Saturday in late autumn, and I understood immediately why she had positioned it the way she had. The room was designed by someone who knew exactly what they wanted from it and who had taken the care to make it that. I am going to take care of it the same way. I also want to be clear about something regarding what the hospice physician's declaration said and what it did not say. It said that my mother had been on a continuous sedation protocol from January 28th through the date of her death. It said that on February, specifically, she was in a condition that precluded the execution of legal documents, the management of financial affairs, or any formal decision-making process. It said this based on the contemporaneous medical records and on the physician's professional assessment of her condition on that date. It did not say that my mother was unconscious every moment of February 9th. The sedation protocol involved titrated doses that were managed to maintain comfort, and that might have allowed for brief periods of diminished consciousness rather than complete unconsciousness. What the declaration said was that whatever state she was in on that day was not the state of a person capable of understanding and freely executing a property transfer. That is a legal standard and a clinical standard, and the physician was addressing both. The opposing side's argument that she might have had a lucid interval required them to produce evidence that the interval met that standard. They produced none. There is something I want to say about Petra that is honest rather than protective. I have two versions of what I believe happened. In the first version, Petra had a document created, and she and the unidentified male visitor, who was likely a notary or someone acting as a notary, went to the hospice on February 9th and presented the document and managed to obtain something that was then presented as my mother's signature, regardless of whether my mother understood or consented to what was happening. In the second version, Petra created or had created a document with a backdated signature and had it notarized by someone who either did not witness the actual signing or who was not told the full context of what they were notarizing. I do not know which version is true. I know that Sandra Birch was a real notary with a valid commission, and that the question of what actually happened in whatever room Sandra Birch was in when she placed her seal on that document is something the prosecutor's referral and the Notary Commission review are presumably working to establish. I hold both versions with the specific humility of someone who knows the facts without having been present for the specific events that the facts point to. The record said enough. I do not need to know more than the record said to know what the outcome should have been and to know that the outcome was correct. There is something I want to say about the will and about what my mother had intended. The will that her attorney had prepared 8 years before her death left the house and all other assets equally to both daughters, equal shares. That was her decision, and she had made it 8 years before the illness and 8 years before Petra had become her primary caregiver, and 8 years before any of the specific circumstances of her last 2 years had existed. The fact that Petra had been the primary caregiver is real. She had done real work in those 2 years that I had not done because I was in Cleveland and she was in Columbus, and she was the one who had driven to Newark when things needed to be done, and I had not always been available to do the same. I do not minimize that. What I want to say is that the mechanism for recognizing that contribution is not a unilateral property transfer. It is a conversation. It is an updated will. It is a decision made by a person with capacity who understands the decision they are making. My mother had a will. If she had wanted to change it in the last years of her life, she could have changed it. She had not changed it. The will said equal shares. The document Petra produced was not a reflection of my mother's decision. The records of my mother's condition on the date of that document said so. The court agreed. I am not able to say with certainty what my mother would have decided if she had been capable of deciding in her last weeks. I know what she had decided 8 years earlier when she had full capacity and the time to think about it. Equal shares. That is what the will said, and that is what I believe she meant. My mother was a person who handled things. She kept her records. She had a will. She had a survey from the time she bought the house. She pulled out that survey when the neighbor disputed the oak tree, and she was right about the oak tree because she had the survey. She built the reading room she had wanted. She kept 47 watercolor paintings in the closet, dated on the back in her handwriting. She was organized and deliberate and precise, and she did things carefully, and she left records of the things she did. The deed that Petra filed did not reflect who my mother was or what she wanted, and the records that said so were the records my mother's care team had created from caring for her carefully in the last weeks of her life. The records she left behind and the records that were kept about her together said what was true. The court confirmed it. The house is mine, and I am taking care of it the way she would want it taken care of. I am trying to be as organized and deliberate and precise as she was. I have her survey in a folder. I keep the garden. I have not yet taken a watercolor class, but I have thought about it. I think she would find this either amusing or appropriate. I am not certain which, perhaps both.